You're at home, sleep in your bed, might be alone, might have your significant other with you or kids down the hall. It's late at night. You wake up hearing a noise outside your door. Floorboards creaking or somebody moving things around. You realize that there's an intruder. You don't know what he's there for. Could be to just take a few things. Could be to harm you or your family. So you grab a handgun or other deadly weapon and to confront the entity or the individual. Intent on using deadly force if necessary. Could you do that? Would you feel justified in taking that person's life if your life or your family's life or your possessions were at risk? These questions led me to perform an immense amount of research on the Castle Doctrine and the laws surrounding it for a composition class that I was a part of in another college. And partly through some personal experience by having my car broken into and some things stolen. The subject is, the reason why I chose the subject is it's had an immense impact on our nation through certain trials that I'll get into later in the speech. In that citizens have the right to use deadly force if necessary. The Castle Doctrine law was enacted to allow homeowners the ability to use deadly force in the event of personal safety being at risk or possessions being at risk from an intruder or somebody intent to do bodily harm. Through this speech, I'm hoping to clarify or introduce the definition of the Castle Doctrine, the nature of its applications, and a couple case studies that use this law as a defense. Benjamin Levin, a current Clemenco Fellow at the Harvard School of Business, posted an article in the Harvard Law Review in 2010 that states the history of this doctrine is based on the abolishment of the 17th century English common law known as the duty to retreat. The duty to retreat is an old English law that states that if a person is faced with bodily harm or someone that intends to do them bodily harm, they have to retreat to the furthest wall or to their house or castle. American lawmakers saw this as being cowardly, and in 1921, the U.S. Supreme Court discarded the duty to retreat law. They in turn adopted a law called a man's home is his castle, and which is a principle of equity. In the state of Wisconsin, Mark Hinston, a practicing attorney in the city of Racine, wrote an article for the Wisconsin Lawyer publication on June 1st, 2013 that appeared in the State Bar of Wisconsin website in July of 2014 that defines the Castle Doctrine law for our state as Wisconsin Act 94. In it, he states that a homeowner is immune to prosecution in the use of deadly force while defending himself, his possessions, or his home, motor vehicle, or place of business. It also eliminates the need for the person being violated to flee the situation before he or she used deadly force. Both definitions are based on a man's home as his castle principle of equity. So now that we know some of the history behind the development of the Castle Doctrine law, I want to present some of its applications by other states. Florida is the first state to adopt the Castle Doctrine law on October 1st of 2005. The Castle Doctrine law in Florida gave rise to the Stand Your Ground Law statute of 776.013. In it, it states that it is an extension of the law and extends the boundaries from a man's house or castle to any other place that a person has a right